Hello, everyone, and welcome to our panel, which is Litigating for Animals in a Climate Crisis. I'm Catherine Meyer. I'm the director of the Animal Law and Policy Clinic at Harvard Law School, and I'll be your moderator for this panel. Before we start, I want to thank our platinum sponsors, the Brooks Institute for Animal Rights, Law and Policy, and Miyoko Creamery, which makes vegan butter and also lots of other delicious vegan treats. The session will include pre-recorded presentations from our panelists and then a live Q&A. With all of that out of the way, I'd like to introduce our esteemed panelists. The first one is Eric Blitzenstein. Eric is the Director of Litigation for the Center for Biological Diversity, where he oversees and coordinates the massive amount of litigation that you all know the center engages in. He is one of the nation's foremost leading experts under the Endangered Species Act and how to litigate under the various wildlife laws, particularly the ESA. And I can say that confidently because he's also my former partner, my law partner at Meyer, Blitzenstein, and Eubanks, where he litigated many groundbreaking cases under the ESA and other environmental statutes. Next, we have Christina Stella. She's a managing attorney at the Animal Legal Defense Fund, where she litigates on behalf of farmed animals as well as animals in the wild and in captivity. Christina primarily focuses on increasing transparency in the industrial agriculture system and challenging industrial agriculture practices that harm animals, the environment, and public health. And next we have Tara Heinzen, who's the legal director of Food and Water Watch, where she heads the organization's legal work on in support of their efforts to ban factory farming. Before joining Food and Water Watch, she worked as an attorney at the Environmental Integrity Project, where she focused on enforcing laws that regulate factory farm water and air pollution and restoring the Chesapeake Bay. So without further ado, welcome to our panel presentation, and I hope you enjoy it. I'm sure you will.
Hello to everybody, and thank you for being at the conference and caring about animal protection and particularly the intersection between animal protection and the climate crisis, which is upon us. What I'm chatting about today is use of the Endangered Species Act in dealing with the climate crisis. It's an impact particularly on endangered and threatened species, endangered or threatened as a result of climate change. The Endangered Species Act is an extraordinarily far-reaching statute, and in many respects, it's one of the most powerful laws that exists for addressing myriad impacts on wildlife and potentially for addressing impacts on wildlife from climate change. And I'll talk about some of the potential for that and some of the pitfalls or potential roadblocks to that as I go along. But one of the important things I want to stress at the outset about the Endangered Species Act is that not only does it have very far-reaching protections, but it has a very strong citizen suit provision, which essentially authorizes, empowers any person who is fits within Article 3 standing to bring a challenge to a violation of the act or a failure to carry out the act. So in contrast to a number of the statutes that people are familiar with that ostensibly can be used to protect animals but do not have that kind of citizen suit opportunity, the Endangered Species Act is a very, as I say, a particularly strong law, at least in its potential application. It's a statute, just by way of very brief background, that was passed in 1973. It was signed into law by Richard Nixon and was overwhelmingly passed by Congress. And so that shows you sort of how far we've moved away from a bipartisan support for certain kinds of values to where we are today. But in any event, this is Richard Nixon's signing statement referring to the fact that nothing is more priceless, more worthy of protection than the rich array of animal life with which our country has been blessed, a many-faceted treasure of value to scholars, nature lovers, et cetera. So it was an extraordinarily broad, far-reaching statute, really the most far-reaching protection for wildlife in many ways that the country had ever enacted. up to that point, and still remains one of the strongest statutes for protecting certainly imperiled wildlife that exists anywhere in the world. The purpose of the statute, as it initially enacted, as you can see here, was based upon findings that various species of fish, wildlife, and plants have been rendered extinct as a consequence of economic growth without adequate concern and conservation, and that species of fish, wildlife, and plants are of aesthetic, educational, historical, recreational, and scientific value to the country. And the purpose was, again, this very broad and far-reaching purpose to provide a means whereby the ecosystems upon which imperiled species depend may be conserved. So not just looking at species in isolation, but looking them as part of an overall ecosystem. Particularly at that point in time, that was an extraordinarily sort of far-reaching and enlightened understanding of the need for human beings to at least try to address what was recognized as ongoing threats to species of all kinds. Now, at that time, the principal threats to species ongoing existence were twofold. They were seen to be hunting activities, fishing, hunting to excess. Obviously, many people don't agree with those activities at all. I don't, but even if you do, there was a recognition that you should not be hunting species to extinction. So that was one of the principal concerns and one of the major purposes. And the other purpose, which feeds directly into climate change, was a concern with ongoing habitat loss and degradation. And that was mainly through unchecked development, but it really was all kinds of ecosystem related impacts at that point in time. And so those were the overarching purposes of the statute. Now getting into how all of these purposes and what the statute can mean, particularly for climate change and climate change related litigation, nothing can happen under the statute unless a species is listed as endangered or threatened. And there's a broad definition of species which encompasses any species of fish or wildlife and any distinct population segment of any species of wildlife which interbreeds when mature. And so it includes not only total species, but also subspecies, what are called distinct population segments. Listing a species can be based upon any one of a number of factors. The most relevant two factors for our purposes are present or threatened habitat loss, modification, or curtailment of the range of a species, or what's referred to broadly, the last listing factor is any other natural or man-made factor that may threaten a species' existence. So that obviously encompasses climate change on top of the habitat loss factor. Species can be listed under the Act in one of two ways, either on the own initiative of the two agencies primarily charged with implementing the statute, which are the Fish and Wildlife Service, part of the Interior Department, for most terrestrial species, and for most marine species, the National Marine Fisheries Service. So they can list a species on their own. They almost never do that since the history of the Act. Almost every listing under the statute has actually been driven by the other way species can be listed, which is through a petition process. An extraordinary opportunity given to anyone to submit a petition supported by scientific evidence. And then there are mandatory timeframes that kick in within which these agencies have to decide whether the best available science supports listing the species or doesn't support listing the species. And if the agencies fail to respond, then one can bring a lawsuit to get those timelines required to be followed. So, as I say, an extraordinary petition process that really has driven almost every listing under the Act, including every listing to date, which has been the result of climate change impacts. Without that petition process, it simply would not have happened. So those who challenge, citizen suits under the Act, they have to reckon with that history of citizens actually driving enforcement of the Act, including with respect to climate change impacts. Two crucial definitions of the statute deal with endangered and threatened. And those are particularly important when it comes to climate change, as I'll explain in a moment. But the definition of endangered is any species which is in danger of extinction throughout all or a significant portion of the species range. And threatened, in contrast, is any species which is likely to become an endangered species within the foreseeable future throughout all or a significant portion of its range. So there's a temporal immediacy component to the two different definitions. And those become important when we're dealing with a species in the case of the following, which is the polar bear, the first sort of listing case study I wanted to talk about. And the polar bear, which is currently listed under the Endangered Species Act as a threatened species, was a species that was subject to a petition submitted by the Center for Biological Diversity, arguing that although the polar bear's population numbers had not plummeted in real time, and although there were other threats to the species that should be addressed, including arguably excessive hunting, aboriginal hunting, and other kinds of hunting activities, sport hunting in various respects, the real problem facing the polar bear inevitably was going to be the loss of sea ice, which is critical to the polar bear's continued existence. And the center submitted a petition asking that the polar bear be listed as endangered or threatened. And in 2008, the Fish and Wildlife Service decided the polar bear would be listed as threatened rather than endangered. And that actually had important legal consequences, the distinction as far as the polar bear goes. And I'll get into that in a little bit later when I talk about the take prohibition in the ESA. But for purposes of the immediate decision that was made, both the center and the plaintiffs challenging the decision said that the polar bear should be listed as endangered because it would inevitably go extinct as a result of climate change. And then on the other hand, we had the state of Alaska and various industry groups challenging the listing and saying the polar bear shouldn't be listed at all. The climate change was too speculative. We don't know what's going to happen in the future. The polar bear may turn out to be perfectly fine for reasons that were never clear. But in any event, both sets of plaintiffs challenged the listing. And there's a lot of litigation that happened over this, and people who are interested should read both the district court decisions and the DC Circuit decision. But to summarize very briefly, the district court ultimately upheld the listing as threatened. The district court gave the government an opportunity to explain why the polar bear was not endangered, even though everybody agreed, the scientific community agreed at the very least, that the polar bear would inevitably become extinct. But the Fish and Wildlife Service, the Justice Department said, well, yeah, but that's not for a long time. And endangered really means an immediate kind of threat. And so therefore, endangered isn't really justified. And the district court, Judge Sullivan, upheld that determination. But the district court also said that the polar bear clearly did meet the definition of a threatened species, as the Fish and Wildlife Service had determined. And so this went up to the DC Circuit, and the DC Circuit, in a very important precedent-setting ruling, also upheld the polar bear's listing as threatened and rejected myriad challenges to that. And one aspect of that I would want to mention very quickly is that the time frame that the Fish and Wildlife Service used to evaluate how long it would be before the polar bear would be in a state of endangerment, not necessarily extinction, but endangerment, is 45 years. And that's based upon those definitions I mentioned, which said that the services have to look to whether or not a species will become endangered or threatened within the foreseeable future. And the service said in the case of the polar bear, foreseeable future was 45 years based upon various models. And the courts basically gave the service a huge amount of discretion in what the foreseeable future would be for any particular species, and said that 45 years to look at what was going to happen to the polar bear and sea ice during that time frame was a reasonable science-based judgment that they were going to defer to. That gets us to another listing case study, this fellow, the walrus, which is, you might think, in a very similar posture to the polar bear, as a species that's very dependent upon sea ice for its existence. But in regard to this species, although for many years the Fish and Wildlife Service had said the species probably did warrant listing, during the current administration, the service reversed course and said the polar bear did not warrant listing. And in this case, they used two different timeframes for the foreseeable future. They used a time frame of 2100 for the disappearance of sea ice and the loss of sea ice, and said, yeah, we can predict that that will happen. But with respect to how the polar bear would respond to that, the service said, we're going to only use a year 2060. Why? Because we don't know how the walrus is going to adapt. Walruses are really smart, and they may figure out how not to use ice as much in the foreseeable future. They may adapt to using what are called land haul-outs for breeding and for other crucial life activities. And so we don't really know. So we can't say that it's going to become endangered or threatened within that 2060 time frame. That was actually upheld by a district court in Alaska last year. And that's another case brought by the Center for Biological Diversity and other groups. And that's being appealed to the Ninth Circuit right now. So we'll see how that one pans out. The other one I wanted to mention is a species called the Florida Keys moleskink, this guy right here, because it shows that it's not just sea ice that we're talking about and polar regions. This is a species that lives, as the name implies, in the Florida Keys. It is at great risk from being inundated by sea level rise. And in this particular situation, the Fish and Wildlife Service, just to show how ad hoc this seems to be, they picked a date of 2060 also to look not only at the inundation timeframe, but also how the skink would arguably react to inundation of its habitat in the Florida Keys, and concluded again during this administration that even though a huge percentage of the species' habitat would be inundated by the inevitable sea level rise, we don't really know how that's going to affect the skink. Maybe it will move our upland. They even actually went so far as to say maybe the skinks would figure out how to raft to other islands that were higher than the one that they were in trouble on. But in any event, the center challenged that as arbitrary and capricious. And within the last several weeks, actually, a federal district judge in Florida found that that was arbitrary and capricious, contrary to the Endangered Species Act, and told the Fish and Wildlife Service that it had to reconsider that determination that the skink was not endangered or threatened by sea level rise. So that's just a snapshot of the kinds of listing issues that are coming up. Now, what happens if a species gets listed because of climate change? Well, it gets all kinds of protections from lots of impacts that otherwise are affecting the species, such as, for example, hunting in the case of the walrus or the polar bear, such as habitat development in the case of the skink. But what about climate change itself, which is the reason why the species are getting listed? And there are two principal parts of the statute that come into play that are critically important. One is called Section 7 of the Endangered Species Act. And this has really been called by many people, especially animal lovers should like this, the pit bull of the Endangered Species Act. And this is a provision which says that, among other things, any federal agency action which jeopardizes the continued existence of a listed species cannot take place unless this extraordinarily high-level committee, referred to by many colloquially as the God Squad, approves that action happening. And so on its face, it would look like Section 7 would be a really important check on agency conduct, which endangers a threatened species. There are all kinds of agency actions, many going on right now, as people know, approving oil and gas operations in various places, allowing all kinds of habitat loss, which increases greenhouse gas emissions. Why are those kinds of activities not subject to major Section 7 prohibitions or restrictions? Well, the answer is based heavily on an analysis that has been done, has been in place by the Fish and Wildlife Service for many years. And I'll just stop briefly for a moment and show yet another species affected by climate change. Section 7, why is it not having an impact? This is one of the staghorn coral species, just to show you the range of impacts. But to go back to the reason why we don't have a Section 7 prohibition that has been widely adopted, and that is because of something called the Bernhardt Memo, issued by Bernhardt when he was now the Secretary of Interior, Bernhardt, but then he was the Solicitor of the Interior. And he basically said in so many words that even though climate change may pose an overall threat, cumulative threat, any one particular action is just too attenuated, too difficult to connect to an impact on a particular species. And without going into all the intricacies of Section 7, which we can follow up on when people have questions or otherwise, basically, in order to get into that whole process, you have to meet what seems to be a very low standard of a may affect the listed species. And what Bernhardt concluded was we can't even meet that effect because even though greenhouse gas emissions go into the environment generally, it becomes too diffuse. It just is impossible to link any particular greenhouse gas emission based upon the then available science to impacts on a species in a particular place. Right now, there is pending litigation over that very issue brought by a number of states as well as conservation groups, including the Center, in litigation concerning the Trump administration's reversal of position of Obama administration standards on auto mileage fuel emissions, arguing that the Section 7 protection, the Section 7 process should come into place based upon current science showing increasingly that we can link, especially major emissions such as those from automobiles and fuel efficiency standards, to impacts in particular regions and particular species. So that is a crucially important piece of litigation currently playing out. And the only other thing I want to mention specifically about the protections is in Section 9, which is the take prohibition of the statute. And this is also very broad and provides that no federal action, in fact, any private action, can take a listed species, which is defined as kill, injure, and can also include habitat loss and modification. But once again, so far at least, this Bernhardt Memo and other agency positions have made it extremely difficult. And the one thing I would mention is in the polar bear, the Fish and Wildlife Service, while it listed the species as threatened, also adopted a rule at that time called the special rule you can only do for threatened species that said that for the polar bear, the cause of the polar bear's listing, which was climate change, would not actually be considered to be a take. So they excluded climate change from the take protection with regard to the polar bear, which again highlights why it's so important that species, when species are listed as threatened as opposed to endangered, because that opportunity doesn't exist with endangered species, only threatened species. So there will be lots of future analysis, and people are looking these days at bringing a take case of some kind under the citizen suit provision. I just wanted to mention two other species. Here's the desert tortoise, and here at the end is the Indiana bat. And I just want to mention them because climate change, if we're going to address it, and we all hope that finally, maybe it's not too late, that we do try to address climate change because of all the horrible impacts on species. But when we shift to renewable energy, we have to be able to do it in a way that is friendly to wildlife as well. And the tortoise is a good example of a species that has been hit hard by vast solar plants that were put in its desert habitat with very little concern. Many thousands of tortoises were killed or transplanted to places where they had no idea how to survive. Indiana bats are an example of a species, along with many birds and other bats, that can be killed by industrial wind power when wind power put in the wrong place. So the final point I would make is, as we address climate change and its terrible impacts on listed species, let's not make the same mistakes we made before. We have to move to renewable energy, but do it in a sensible, animal-friendly, and wildlife-friendly fashion. So with that, I would close and turn it over to the next presentation.
All right, well, thanks so much for having me for this panel. There are so many ways to use the law creatively to address climate change's impacts on animals, but I'm going to specifically focus on the climate change impact of factory farming, how climate change is exacerbating the harms of this industry, and a few of Food and Water Watch's legal strategies to address these impacts. So it probably goes without saying at this conference, but factory farming is a major driver of climate change. And as this slide shows, even though the CO2 impacts of this industry aren't that dramatic at about 5%, there are other greenhouse gases of concern that are very driven by this industry. So nitrous oxide, it's almost 300 times as powerful a warming agent as CO2, and livestock contribute more than half. Methane, similarly, it's more than 80 times as powerful as CO2 over a 20-year time period, and livestock contribute about 45% of all methane emissions. And this share is increasing. Overall, globally, factory farming and other livestock production contributes 14.5% of greenhouse gas emissions. And a lot of that is coming from producing and processing livestock feed. So what that tells us is that this is about factory farming's ways of producing animals. It's not just about livestock inherently producing a lot of emissions. It's about animals that are kept in confinement and fed very high emissions producing feed. What we also know is that factory farming is proliferating. These facilities are not only becoming more numerous, they're becoming larger and more concentrated in certain communities. The total number of livestock on factory farms rose by 20% between 2002 and 2012, so just over a 10-year period. And over a 15-year period from 1997 to 2012, the average dairy grew 50% larger, the average hog farm grew nearly 70% larger, the number of what they call broiler chickens or meat chickens on factory farms rose to over 1 billion, and the average egg-laying operation grew 74% larger. So this industry is growing at a rapid pace. And along with that, expectedly, the emissions from the industry are rising as well. So unlike many industries, livestock sector emissions are expected to continue increasing for decades, even while other sectors have to dramatically decrease their emissions to meet global climate targets. And what that means is that the industry's share of global emissions is going to become increasingly significant. And you can see on this slide, the pink columns are growing over time. That's the livestock share of emissions. And so by 2050, it's expected that livestock's share of greenhouse gas emissions will be a huge portion of the total emissions. And even now, the largest 20 meat and dairy companies are emitting more greenhouse gases than Germany, Australia, Canada, the UK, or France. So already this industry is a huge source of emissions. And the next slide shows that even just the top 5 companies right now are emitting more than ExxonMobil, Shell, or BP. And all of these data come from the Institute for Agriculture and Trade Policy and its report, Emissions Impossible. So what are we going to do about this industry's huge climate footprint? The first legal strategy I'm going to talk about involves the federal government's financing of new and expanded factory farms. Unfortunately, federal agencies have played a huge role in enabling the industry's expansion and consolidation through direct financing and loan guarantees. And several years ago, Food and Water Watch submitted a Freedom of Information Act request for the Department of Agriculture Farm Service Agencies financing data for livestock operations. Over a 7-year period of time, we see that billions of dollars have been provided to this industry in direct and guaranteed loans to purchase and operate factory farms. Now, because of secrecy provisions in the federal farm bill, these data are aggregated, but because of the way the numbers shake out and the average loan size is enormous, it's reasonable to conclude that most of this financing is of factory farms, not smaller scale livestock production. There are some limitations to Farm Service Agencies' lending practices, and of particular importance, FSA is what's called a lender of last resort. And what this means is that borrowers from the Farm Service Agency have to be unable to obtain sufficient credit elsewhere without the guarantee. And what this means is that the Farm Service Agency is incentivizing banks to lend for factory farm construction because FSA is going to issue the guarantee that will protect the bank in the event of default. And the upshot of this is that factory farms are being built that wouldn't be built if it weren't for FSA's loans and loan guarantees. So essentially, we are all the public paying for factory farms thanks to this bad public policy. So we're currently using a federal law, the National Environmental Policy Act, NEPA, to try to make it harder for the Farm Service Agency to promote the factory farm industry. Now you're going to hear more about NEPA in more detail from Christina Stella on this panel, so I'm just going to go over a couple highlights relevant to our case. NEPA is what's referred to often as the federal government's charter for protection of the environment. And it requires environmental review for federal government actions that are considered major. The idea is to take a hard look at the impact that an action is going to have before we commit resources to it. The Farm Service Agency has its own Nepa regulations, and they require an environmental assessment or review for its loans and loan guarantees to large CAFOs. So that basic level of review is, as I said, called an environmental assessment, and it requires the agency to consider direct, indirect, and the cumulative environmental impacts to potentially impacted resources. Now, this review is intended to be very broad. The agency is supposed to look at air pollution, greenhouse gases, water pollution, water use, community impacts like traffic and noise, and the impacts from reasonably foreseeable actions that are related to this action. The agency also has to look at alternatives to the proposal that might be less harmful, but that would meet the project's purpose and need. But it doesn't require or prohibit the agency to take a particular course of action, even if the impact might be significant. NEPA is really all about fostering good process and informed decision-making. And also very important, the environmental assessment requires public notice and comment so that interested and impacted citizens can comment on the draft environmental assessment and can challenge it in court if it's inadequate. And this can also lead to a much more rigorous process and potentially the adoption of measures to reduce harmful environmental impacts, or even the selection of a less harmful project. So one of Food and Water Watch's cases is a challenge to a Farm Service Agency loan guarantee for a very large chicken confinement in Maryland. This is in an area that's already completely saturated with concentrated animal feeding operations. And as a result, the air quality is seriously impaired. Waterways are heavily polluted with nutrients, including the Chesapeake Bay. And we found out about this proposed factory farm and the environmental assessment several years ago when local community members got in touch with us and had serious concerns about this project. So they submitted their own comments as part of the public process, including about air pollution and other impacts. We supported them by submitting comments as well. But of course, the Farm Service Agency moved forward, said that there would be no significant environmental harm, and issued the loan guarantee. And that operation is now running today. But we challenged the environmental assessment in the DC Circuit. We first brought this case in 2016. It's been moving its way through the courts. We recently won on standing below in the district court, but we did lose on the merits. So we are appealing right now in the DC Circuit Court of Appeals. And our case is heavily focused on the fact that Farm Service Agency did not look at the cumulative impacts of this facility in the context of all of the other factory farms in the region. And we're very concerned that if the FSA continues to overlook these aggregate impacts on the climate, on water, and on communities, it's going to be that much harder to stop factory farm expansion. Now you'll hear more about this, but there's a new federal rule that's going to eliminate the Nepa review in these circumstances completely. Some of this recent litigation, including possibly this case, has clearly gotten federal agencies' attention because the recent federal Nepa rollback rule created a carve-out from the definition of major federal action specifically for FSA and Small Business Administration loans and guarantees. So under the new rule, loans like this one won't trigger NEPA at all, meaning no notice to local communities, no environmental review, and one fewer tool to challenge this industry's climate emissions. So we're also challenging that rule, and we'll do whatever we can to keep this legal theory viable. I'm also going to talk a little bit now about how we're opposing factory farm biogas as a false solution to this industry's climate change contributions. As I mentioned, methane is an extremely powerful and important greenhouse gas, with much more of the warming potential than CO2 over a 20-year time frame. And as I mentioned, livestock are responsible for nearly half of methane emissions, and that share is increasing. Now, anaerobic biogas digesters are increasingly being put forth as a solution to this climate change contribution. These facilities collect the biogas from factory farm waste storage, and they use it either for on-farm electricity or to create biomethane, which they inject into gas pipelines and then rebrand as renewable natural gas. But in fact, digesters only capture about half of the methane produced as a result of factory farm waste storage practices. The anaerobic conditions that these facilities store the waste in are what generate the methane in the first place. So these factory farms are actually only capturing the greenhouse gas emissions that could be avoided by not keeping animals in this intensive confinement in the first place. So they're not very effective. They're also extremely expensive and heavily subsidized, which we're concerned detracts from investment in true renewable energy. And our biggest concern at Food and Water Watch is that this technology threatens to entrench factory farming because it's an investment in new infrastructure and connections to fracked gas pipelines, which in turn entrench the natural gas industry by investing in new pipeline infrastructure and greenwashing gas as renewable when we should be moving towards electrification. So we want to keep biogas from getting too established however we can. And one of our legal strategies to do that is that we've intervened in a California Public Utilities Commission process. The process is intended to determine first whether biomethane is a cost-effective means to reduce short-lived greenhouse gas emissions like methane. And if so, what should the target concentration of biomethane be in California's utilities energy mix? So we think that it's not cost effective, and we're going to be arguing that it is not cost effective because if the commission takes a broad approach and looks broadly at the scope of what impacts it should consider, it will find that the high social costs of factory farming and biogas make this not a cost-effective thing to do. And second, because of that, the target procurement goal should be zero. They shouldn't be setting a target to create more biogas and entrench factory farming in California. So we'll be advocating for as little biogas in the energy mix as possible. And if we don't like the outcome, there is an appeal process that we can engage in. We think this is an important strategic opportunity to prevent large new investments in biogas and related infrastructure and instead promote electrification, especially because so often as go California goes the country, and this policy could set a very important precedent. So I'm going to wrap up by briefly discussing a legal strategy now related to how climate change is actually affecting factory farming. This is a picture of flooding in North Carolina after Hurricane Floyd, when you can see that the impact on animals and the environment was absolutely horrific. These are hog confinements in North Carolina that were not obviously able to withstand the floodwaters, and the loss of animal life was tremendous, as well as just the overflowing of huge waste impoundments into rivers and people's homes downstream. It was a huge environmental disaster. And we know that this is going to become more and more common. This is a newspaper article from just this past spring about manure tanks overflowing in Iowa, because we know that storm frequency is becoming much more unpredictable with climate chaos. Now, just to take a step back, factory farms, as I've alluded to, store waste in these huge pits and lagoons, and they spread it on cropland. Now, they're supposed to do that in a way that allows nutrients to be used by crops instead of running off into waterways or seeping into groundwater, even though this is mainly a waste disposal process. Under current EPA rules, factory farms are supposed to maintain waste storage capable of withstanding what's called a 25-year, 24-hour storm event without overflowing. So that's the storm size that is expected to occur in a one-day period only every 25 years. Now we know that increased flooding and storm intensity in the Midwest and elsewhere is making it harder to predict when operators will safely be able to apply these massive quantities of liquid waste to crop fields. And we know that this will lead to more and more cases of emergency dumping. So when waste storage facilities get too full, they threaten to overflow, and state regulators will allow operators to spread it on land, even if the ground is saturated or frozen, at huge risk to wildlife and water quality. Now, EPA's Clean Water Act permit rules for this industry have just completely failed to keep up. Current waste storage requirements for this industry are based on a rainfall atlas that predicts rainfall by region, and it was created 60 years ago. So right now, what's considered a 25-year, 24-hour storm event is not based on modern storm data. It's based on this antiquated atlas. And so we're not keeping up with the recent trends in climate change when we're setting our requirements for this industry. And flooding is increasingly going to lead to overwhelmed waste management systems and land disposal at dangerous times. So one thing we've done to counter this is that we filed a rulemaking petition with EPA in 2017 to update its CAFO regulations, in part to reflect modern storm data due to climate change and prevent these environmental and animal welfare disasters. That petition for rulemaking is currently pending before the EPA. And in the meantime, we're also commenting on state-issued Clean Water Act permits to urge them to go above and beyond these weak rules that EPA has set and use better storm data and more protective waste management requirements, which then tees up the ability to bring potential permit appeals and try to force this issue forward. So I'll just wrap up by saying I think it's increasingly critical to address the interplay between factory farming and climate change, and the role of agribusiness in creating the climate crisis doesn't always get as much attention as it deserves. So I really appreciate the opportunity to talk about some of these ideas, and thanks for participating.
Hi everyone, my name is Christina Stella and I'm a managing attorney at the Animal Legal Defense Fund. And today I'll be talking about our efforts to protect the National Environmental Policy Act and the Endangered Species Act, which are two of our most important environmental laws that we use to advocate for animals and the environment. So I know that you heard about either one or both of these laws already from Eric and Tara, so I'll just give kind of a quick overview. Both NEPA and the ESA were passed in the early 1970s, and both laws really reflect the increasing focus on environmental protection that was really coming into the fore at that time. They are considered to be our foundational or bedrock environmental laws, and generally speaking, they require the federal government to consider and protect the environment and threatened and endangered species when making decisions and taking action. So of course, because they were enacted before we had our current understanding of climate change, the laws do have some limitations. But as you heard from Eric and Tara, as environmental and animal advocates, we have successfully used these laws to make sure that animals are accounted for when assessing impacts on the environment from climate change. So while these laws are not perfect, they are some of our strongest tools, and we need to protect them until we're given more contemporary tools directed more specifically at climate change. So the National Environmental Policy Act sets up a two-tier environmental review process for any discretionary, quote-unquote, major federal actions that may significantly affect the human environment. So basically, whenever the government has a choice among different options to accomplish a particular goal, it triggers NEPA and requires the government to figure out which option will have the least impact on the environment. So under NEPA's review process, federal agencies have to consider the environmental impacts of their decisions by preparing either an environmental assessment or a more detailed environmental impact statement. Agencies are required to include the public in their review process, and they also have to consider alternatives to their proposed action that would have a lesser impact on the environment, as well as mitigation measures that could lessen the impact of their preferred action. The agencies also have to consult with expert agencies like the Fish and Wildlife Service or the National Marine Fisheries Service that have scientific expertise regarding impacts of different actions on specific species and environments. The National Environmental Policy Act also created the Council on Environmental Quality, which is an executive agency in the federal government that issues NEPA regulations that apply across the federal government. And so CEQ's regulations are in addition to the regulations that individual agencies enact for their own programs. CEQ's job overall is to ensure that NEPA is complied with across all federal agencies. So from the 1970s until this year, CEQ's regulations under NEPA allowed for consideration of climate change impacts, meaning, impacts that are longer term and somewhat unpredictable. So just some examples of how the prior regulatory scheme made these considerations. Number one, agencies had to consider a very wide scope of effects, including indirect effects and cumulative effects. So they looked beyond just the immediate and direct consequences of an action to more, again, long-term, potentially unpredictable, indirect, direct, and cumulative effects. When determining whether an action would have a significant effect on the environment, which is one of the triggers of NEPA's review process, agencies had to take into account whether there were highly uncertain or unknown risks from the action. And if there were, then they would have to consider those in NEPA review. Agencies also had to consider the future effects of their actions that were, quote unquote, reasonably foreseeable, using a standard that was based on scientific evidence of what is likely to happen in the future as a result of climate change. Judicial relief available under NEPA included taking regulations that violated NEPA off the books or halting a proposed action. So it's a very powerful statute in terms of providing relief through judicial review. And CEQ regulations were a backstop. So agencies are free to enact more protective regulations, but had to be at least as protective as CEQ's standards. And an important thing to note about all of these, about NEPA's application, is that the regulations under NEPA apply across many sectors in which the federal government is involved. So that would include, any industries where the government is approving or funding or permitting private actions, and including in industries that, implicate or exacerbate or cause climate change. So that would, of course, include the oil and gas industry, timber industry, factory farming industry, of course. But even beyond that, these would also apply even to projects like building highways or, other kind of construction and development projects. So the application of this regulatory scheme was really very comprehensive and really affects a lot of different industries and decisions that our government is involved in. So this year, the Council on Environmental Quality issued new Nepa regulations that limit both the scope and the depth of the Nepa review process across the federal government, and especially with regard to climate change. And it did this in a few ways. I'll just walk through kind of the comparison between what we had previously to what we have now. So first and foremost, it eliminated a consideration of indirect and cumulative effects. So now the NEPA review process only has to consider direct effects. And direct effects are defined as those with a reasonably close causal relationship to the proposed action. So it really limits the scope of effects that have to be considered in a NEPA review process. Significance is also no longer defined in CEQ's regulations. So now agencies and courts can decide what it means without necessarily having to consider whether there are highly uncertain or unknown risks from the proposed action, as they had to consider before. Reasonably foreseeable now uses a layperson standard, meaning that it doesn't look to science to understand what future effects are likely, and it eliminates consideration of unknowns as our climate continues to change. Agencies now only have to consider practicable alternatives as opposed to possible alternatives, which you had to consider before. And agencies only have to consider alternatives that are within their own jurisdiction. So these two changes combined mean that an agency can decline to take protective measures that it deems too costly or too difficult because of practical considerations, rather than having to prioritize the environment and find a way to mitigate harms to it as it previously had to do. And obviously, because an individual government agency does not necessarily control every facet of the industries that cause climate change, this provision also gives agencies an out, basically, to not have to consider those long-term indirect cumulative effects of their decision-making. CEQ regulations are now the ceiling of environmental regulation rather than the floor. So individual agencies cannot enact more protective environmental regulations that apply to their own programs. They have to issue NEPA regulations that either match CEQ's regulations or are less protective than them. And finally, there is now a special exemption for the CAFO industry. So loans and loan guarantees to concentrated animal feeding operations and slaughterhouses are now completely exempt from NEPA review under something that's called a categorical exclusion. So federal funding of this industry nationwide, generally speaking, does not require any NEPA review process. So these changes together have obviously really changed the scope of NEPA review, and they make it more difficult, if not impossible, to take climate change considerations into account in the environmental review process in a meaningful way. So the good news is that the Animal Legal Defense Fund and many other organizations across the country have filed lawsuits to challenge these new rules. So 2 have been filed on behalf of environmental organizations whose advocacy extends across the industries that impact the environment. So those 2 suits are the Alaska Community Action on Toxics suit and Wild Virginia versus CEQ. There's also one case that focuses specifically on impacts of the rule changes on communities of color and other environmental justice issues. That is the Environmental Justice Health Alliance versus CEQ case. One of the cases is was brought by a group of state attorneys general. That's the California versus CEQ, of course. And then one case was brought by the Animal Legal Defense Fund on behalf of a broad coalition of public interest groups that advocate against the entrenchment of the CAFO industry across the country. So that case is the Iowa Citizens for Community Improvement versus CEQ, and it focuses specifically on that exemption that I mentioned for federal funding of the CAFO industry. And so even though each suit focuses on slightly different interests, all of them argue that the CEQ's changes to the NEPA regulations are contrary to NEPA, go beyond CEQ's rulemaking authority, and are arbitrary and capricious or otherwise unlawful under the Administrative Procedure Act. So all of these cases are fairly recently filed, so they're really just getting started, but we are very hopeful that some, if not all, will be successful in invalidating the new regulations and putting the old ones back in effect. Okay, so switching now to the Endangered Species Act. I believe Eric's presentation covered much of this and very well, so I'll just say that generally speaking, the Endangered Species Act protects threatened and endangered species and their habitats from adverse government or private actions, both by establishing a process for the protection of individual species and also by creating substantive protections for those vulnerable animals who are entitled to protection. So from the 1970s until last year in 2019, the Fish and Wildlife Service and the National Marine Fisheries Service, which are the two agencies that issue regulations under the ESA, accounted for climate change under the law in several ways. So first, the agencies allowed for the protection of both current and future habitat of any listed species, including unoccupied habitat. So this is really important in a climate change context because climate change is forcing species to flee their current habitat for cooler or higher places or places maybe where their prey has moved due to climate change. And they basically will have nowhere to go if those currently unoccupied places are not protected for them now so that they can move into them later as climate change continues to affect them. So this was a really crucial protection that the ESA afforded animals specifically with regard to climate change. Formerly or under the previous regulations, changed circumstances would require a new ESA analysis. So this is really important also in a climate change context because, of course, as climate change continues and new threats arise, those new threats and changes in circumstances would trigger a new review. Effects of an action on threatened and endangered species were also broadly defined and more thoroughly considered. So really the regulatory scheme under the ESA provided for a very robust science-based consideration process. And the Fish and Wildlife Service or the National Marine Fisheries Service could also require mitigation measures so that any proposed agency action would actually have lesser impacts on the environment. Analyses under the Endangered Species Act were site-specific and very detailed. So again, it really provided for a very robust review process. And then finally, under the old regulations, we had something known as the 4D rule. So this applied kind of a blanket default protection for any species listed as threatened under the ESA, unless or until the Fish and Wildlife Service or the National Marine Fisheries Service issued regulations for that particular species. And so this is important because those agencies don't often get around to enacting species-specific regulations, and when they do, it usually takes a very long time. So it was really important that any listed species had a kind of default level of protection until the expert agencies would take further action to protect them. So last year, in 2019, the Fish and Wildlife Service and the National Marine Fisheries Service issued new regulations that are very similar to what we saw under NEPA, limit consideration of climate change impacts when deciding whether to list a species under the ESA, and also how to protect their habitat to ensure their survival in a changing climate. So first, and as we saw with NEPA 2, the reasonably foreseeable standard uses a reasonable person standard, a layperson standard that doesn't account for scientific evidence of what is likely to occur as a result of climate change. Now, unoccupied habitat cannot be protected. No new consultation is required if circumstances change later or if new threats arise because of climate change. Effects considered in ESA analyses now are limited to ones that are directly tied to the agency action and reasonably certain, which eliminates consideration of unknowns as our climate continues to change. And under the new regulations, the Fish and Wildlife Service and the National Marine Fisheries Service have limited power to require mitigation measures that would lessen the impact of a proposed action. Now, under the ESA, review is very broad and high level and expedited rather than that really thorough site-specific analysis that we had before. And then finally, there's no longer any automatic or default protections for threatened species. So now, unless the Fish and Wildlife Service or the National Marine Fisheries Service issue species-specific regulation, threatened animals basically remain completely vulnerable, even after being listed as threatened under the ESA. So these changes really completely undermine what was actually a very thorough and effective statutory scheme for ensuring the long-term survival of vulnerable animals. And not surprisingly, the Animal Legal Defense Fund and others have also brought suit to challenge these changes. So the Animal Legal Defense Fund suit was filed on behalf of the Animal Legal Defense Fund because of all of the work that we do to protect threatened and endangered species, not just in the wild, but also who are in captive animal facilities. The Center for Biological Diversity is leading a suit on behalf of a group of environmental organizations. And then that case, California v. Bernhardt, was brought on behalf of a coalition of state attorneys general. So even though all of these suits represent, slightly different interests, again, they all challenge the new rules as contrary to the Endangered Species Act and in violation of the Administrative Procedure Act. So these suits were filed some over a year ago at this point, but we actually fairly recently amended our complaints in June of this year. So they are relatively, in their early stages still, and currently all three are proceeding in the Northern District of California. So if successful, which we are confident and hopeful that they will be, then the new regulations will be taken off the books and the old ones will be put back in place. So what happens now? Now that the regulatory agencies have acted, it's up to the courts to review their regulations and decide whether or not they are lawful. And the courts will do that through, of course, all of the cases that I just mentioned. But regardless of the outcome of any of those cases, Congress can always amend the statutes themselves to better reflect its intent, for better or worse. Even if all of the branches of the federal government deprioritize climate change protection, state governments can still act. And so that's why it's really promising to see the state AGs cooperating to bring the litigation that I mentioned, which demonstrates that they really are on our side when it comes to ensuring that these laws continue protecting animals and the environment. And while, of course, it is critically important to protect the legal tools that we have, which is why the Animal Legal Defense Fund and others are doing it, we as the public and as animal advocates can and will continue to fight for animals and the environment, even as our tools evolve and even if they disappear. We will continue using any tools available to us, and we will only get more creative in our legal strategies as our tools continue to change. So, of course, most immediately, we hope to achieve success in the courts through the cases that I mentioned to restore the protections offered under these laws so that we can continue to advocate for animals in a changing climate.
All right, I think we're ready for some questions from the audience. And I think the first question will go to Christina, because it relates to what she was just talking about. And that question is there any law related to the application of the same standards of environmental protection by American companies operating abroad? And I guess this would include both an analog to the Endangered Species Act as well as the National Environmental Policy Act.
I'm not quite sure what international analogs there might be. Maybe some of the other presenters might know more than I do.
Eric, you want to take that one?
Sure. So in terms of the application of U.S. law and the statutes we've been talking about, there's actually been a longstanding regulation that the service has had, not changed by the recent regulations. It essentially says the Section 7 process does not apply to U.S. actions that have extraterritorial impact. That was actually a number of years ago in a Supreme Court case that people may be familiar with called Defenders of Wildlife versus Lujan. And it's a very famous case for standing reasons because the Supreme Court erected a very high barrier to standing that the plaintiffs didn't establish that they had sufficient interest in all these different species abroad, written by Justice Scalia. But as a result of that, there's never been a definitive ruling on whether the ESA could prohibit, could actually have any application through Section 7 to extraterritorial action. NEPA has fared slightly better. There's been some rulings which have said that, particularly where U.S. Action sort of takes place both in the U.S. and then has extraterritorial effect, sort of cross-border impacts, that those can be covered by application. But I think it's fair to say that both of those statutes have not had real huge impact on actions taking place and having effects overseas. I've other laws that people may be familiar with is CITES, et cetera, which specifically do apply with respect to international type actions and importation to the U.S. and that sort of thing. But the two principal statutes we've been talking about have had pretty limited effect on actions having effects overseas, and I think that's probably likely to continue to be the case, at least given the current judicial climate that we have. Thank you.
The next question, I think, is for Tara, and it is actually from Joyce Tischler. It says, sadly, for too long, environmentalists have been resistant to challenging the negative environmental impacts of concentrated animal feeding operations. Environmental organizations are finally, after decades, speaking out about some of the impacts. To what do you attribute this reticence, and what do you hope environmental groups will do in the future on this issue?
Yeah, that's a great question. And I think there are a lot of reasons why there's been such a slow start by the environmental community to take industrial agribusiness and factory farming seriously as an environmental problem. I think one reason is that in the early 2000s, actually, a lot of the big green groups did start trying to do work around the water pollution from this industry in particular. And those efforts weren't very successful. And so what we've seen is actually an erosion of EPA's authority under the Federal Clean Water Act to regulate discharges from this industry. And so I think a lot of groups kind of threw up their hands and said, we're going to focus on other equally important issues like climate change. So I'm hoping that the increasing recognition of the intersection between those issues, the contributions to climate change that factory farming has, is going to help drive environmental groups towards more of a focus on this issue. But I also think we face political challenges with a lot of organizations really being reluctant to take on big ag because it is so politically powerful, not just with conservatives, but with Democrats as well. And so I think there's, I don't want to say a unique political challenge with this issue, but agribusiness certainly wields power across the political spectrum. And I think that makes it really difficult to take strong positions for some groups. I do think, though, that there are really important opportunities right now that environmental groups can engage in. One is a federal bill introduced by Cory Booker, Elizabeth Warren, and others called the Farm System Reform Act. And it's sort of Food and Water Watch's North Star for how we want to see progress on this issue, not just environmentally, but across the board. And what this bill would actually do is ban the expansion of new or expanded factory farms nationally, and it would fund a just transition for farmers to get out of the factory farm model and into other forms of agriculture that are more sustainable. So we think this is a really good model that environmental groups should get behind. And there's also really great work happening at the state level to build political power for that work. So moratorium campaigns in states like Iowa, Maryland, and Oregon, for example. I also, though, think it's important to continue expanding on our creative legal theories in this space. You know, one issue I think that's held environmental groups back is that factory farm pollution is kind of a square peg in a round hole for a lot of our environmental laws. So this industry is a major source of water pollution, but that water pollution isn't coming out of a pipe like a wastewater treatment plant. It's harder to measure, it's harder to enforce. Similarly, this is an industry with major air emissions, but they aren't coming out of a stack like at a power plant where it's easy to install pollution, relatively easy to install pollution control technology. So I think those challenges have also held some groups back, and hopefully there is going to be growing interest in thinking outside the box and outside of those statutes for ways that we can hold this industry accountable, because it's really taking over agriculture in this country and the environmental impacts of it are just growing.
Thank you. I'm so glad you mentioned the Booker legislation because I was going to ask you about that. I'm sure people are interested. Do you think it has any chance of passing depending on what happens on November 3rd?
You know, I think it does, because we are hoping that it'll be part of a Green New Deal package, and we can't have a Green New Deal or a just transition that doesn't include agriculture. So I think that it's gotten a lot of sponsors and a lot of support very quickly, even though it really is quite it's a big bill. It would enact big change, structural change, and that's exactly what we need. So it's a heavy lift, but I think it's the change that we need, and I do think it's possible.
Great. And here's a question for Christina, which is apart from the pending litigation that you mentioned over the new Nepa rules, is the expectation that if there's a change in administrations, that those regulations will be withdrawn and the former regulations will be put in place?
Absolutely. That's our expectation and our hope that if a new administration takes over, certainly CEQ, which is an executive agency, then they will revert to the NEPA rules that we had in place before.
Great. And then a question, I guess, for Eric. With the influx of conservative federal justices as a result of Senator McConnell's focus on this, what impact might this have on animal and environmental protection and enforcement using litigation? I would add legislation to that as well. We now have, the Trump administration has had the opportunity to appoint, soon to appoint the third justice. And particularly given all of your presentations, which all touched on the fact that the current administration is pretty hostile to both the Endangered Species Act and to NEPA, the question is, how is this the makeup of the Supreme Court going to help or hinder our ability to do something about climate change? Eric, that's for you.
Obviously, that's a huge question, and I think it applies not only to the Supreme Court, but also to all the lower federal courts. I mean, we have seen a massive shift to the right in the lower federal courts, as well as the Supreme Court during the Trump administration. And I can't even fathom what it would be like if we have that ongoing shift over the next number of years, even putting aside the Supreme Court. So let's sort of hopefully assume a somewhat different scenario where we have 3 justices on the Supreme Court appointed by Trump. Not that that's hopeful, but there's nothing we're going to be able to do about that. And also, we don't know what's going to happen with, obviously, a potential Biden administration response. As people know, there's been discussion of whether or not you could add more justices to the Supreme Court. Short of that, there are questions about whether or not the Supreme Court's jurisdiction can be limited in some fashion, and other potential remedies for what we see as what's going to be the most right-wing Supreme Court that many of us have seen, literally for decades, going back to when Kathy and I quite frankly started litigating, many years ago. And how we're going to try to navigate that is going to be extremely challenging, but not necessarily impossible. I think that one thing to keep in mind is, I like to sort of pick up on Tara's point about thinking outside the box. I agree with that, but I guess the corollary I would put is think outside the box, but not too much. That is, be creative, certainly, in looking for parts of the law that have not been, as litigated as strenuously as they could, but also making sure that those cases are extremely well thought out and well supported, factually as well as legally. Cases that are just too far out there, you're not going to get anywhere with this very conservative Supreme Court. And I don't want to sort of challenge anybody's particular case or idea, but as I think these presentations have shown, there are some great tools there that are in the law right now. And if we can really be effective and strong in how we use those laws, well supported legally and factually, I think we can continue to make headway. But cognizant that if these laws are pushed too far, they will end up in a Supreme Court that is not likely to go, in our direction. And also a court that's going to be very concerning with regard to jurisdictional issues. We've already touched a little bit on standing issues, what Justice Scalia did. We have a Justice Scalia acolyte going up to the Supreme Court. We could assume that is not going to be helpful for even getting through the courthouse door. So we're going to have to be really clever in how we think about how to make sure these cases are well supported from a standing standpoint as well as on the merits of these cases. So I think it's going to obviously have a huge bearing on how we approach what we do. But I think that doesn't mean that we can't use the courts effectively. And I think just the last thing I would say on legislation is that there's a limit to what the court can do when statutes are written in a very strong and clear way. We've got these people who claim to be, strict constructionists and care about the plain language of statutes. We know a lot of that is hypocritical and doesn't necessarily apply across the board. But one of the ways to basically put them on the hot seat is to have the laws written in a way which is very clear and unambiguous in terms of directives to the agencies. And if we do have a Congress which is susceptible to this, making sure that our very effective lobbyists and others don't leave ambiguities that can be exploited by industrial, responsible, those who are challenging these things, as well as more conservative judges, making sure those laws are unambiguous and as clear in their directives as possible on climate change, as well as all the other animal-related issues that we care about.
All right, very optimistic there. So I guess the last question is for Tara from Laura Fox. Since your NEPA challenge relates to cumulative impacts that no longer need to be considered under the new NEPA regs, do you anticipate a renewed standing challenge, Ray, the unavailability of redressability?
That is a great question. Unfortunately, we are still facing a redressability challenge, not even a renewed one. So we're currently on appeal before the DC Circuit and are in the middle of briefing why we can in fact show redressability. I do think that we will face an argument from Farm Service Agency if we prevail on the merits and this environmental assessment is remanded. But FSA has said that it will continue to do NEPA review under the status quo of its existing regulations until it changes its own NEPA rules to mirror the new CEQ rules. So I think we have a really strong argument for redressability, even under the new rules. Obviously, that will change with cases that aren't currently pending, but I think we have a good shot of avoiding it, tanking our case in this appeal.
It's always good to be optimistic about these things.
Yeah. Got to.
All right, I think we're out of time for questions. That was a really outstanding panel presentation by all of you, and these are really interesting issues, and there's a lot to be done. We should all be out there thinking out of the box, as Eric said, not too far out of the box, but bringing these interesting, creative cases and trying to do something about, obviously, greenhouse gas emissions and its horrible impact on wildlife and human animals as well. So thank you all very much.